the topic is public reason, and it's at once a very academic topic, but also I think a very public topic. Just in this past week in the New York Times, there was an article about Governor Pat Quinn of Illinois, who abolished the death penalty, or signed a bill to abolish the death penalty, citing as decisive for him a book of the late Cardinal Bernardin from Chicago, and saying that he had mulled this issue over and was really rereading Cardinal Bernardin, I think his a memoir that he published posthumously that really articulated a religious ethic of life that for him made the case. And the article went on to say that it was controversial among some of his liberal friends because he wasn't citing, they put it, secular reasons to end the death penalty, but one could say public reasons. And you know, there's a big debate about this, including in the public realm, about speech norms and whether it's important for religious people in particular to cite not just religious reasons for laws on important topics, but reasons that can be shared by members of the political community. So that's the the public topic, and it's I'll say a few more words about that later on. I think we can understand how it resonates in political philosophy. It's been a very lively debate, which I was very interested in sort of in the 90s, and I kind of left behind in the late 90s because it didn't seem to be going anywhere. But I came back to it recently, and there's all this new stuff out there, including a great big 600-page book by a philosopher by the name of Gerald Gauss called The Order of Public Reason. And it's still the case that while it's always seemed to me that the idea of public reason is kind of very commonsensical, and in a way I can't see why anyone could disagree with it. I would say that supporters of a kind of minority position in political theory. I think in philosophy it's less controversial in some ways, or not as unpopular, I'll put it that way. But in political theory and law, it's very, every time I say something about it, the American Political Science Association, I'm told that it's clearly a minority position. In any case, so what's the idea? Because I want to be very brief. What I want to ask about this, because it often seems like a very academic debate. The academic debate often seems very academic, because the debate is not straightforwardly about the substance of issues of justice. And in fact, many of these critics of public reason are liberals, and Pat Quinn struck down the death penalty, citing religious reasons. So why isn't what's important that people converge on support for sound principles of justice, irrespective of their reasons? Why would anyone, in the name of liberalism in particular, want to, in a way, police people's speech or police people's reasons? Articulate norms that seem to cast aspersions on, the true grounds that some people have for supporting justice, if those grounds happen to be religious grounds. So indeed, I think there's a challenge here. There's a sort of challenge here. Now, the response of liberals has been, well, there's this problem of legitimacy. The law applies to everyone. We want reasons that are good for everyone to justify the law. The law in the democratic community should be justifiable from everyone's point of view. And so the standard sort of view which Rawls articulates in political liberalism has been, look, we want an account here of the justification of law that's good for everybody, not just good for some. Well, the critics have been resourceful, and they've come back with an alternative conception of legitimacy, which is to say, sure, the law should be justified to everyone in the political community, but that doesn't mean there has to be just one justification. There can be multiple justifications for groups in the political community. And this guy Gauss elaborates this at enormous length, as I said, a good 600 pages. The others as well, Jeffrey Stout has this model of iterative dialogue where we engage with our fellow citizens in sort of the completeness of their views. This kind of resonates with stuff of Michael Sandel's from a long time ago. We don't need an unencumbered self, and Sheila Ben Habib, the concrete other. And, there are a lot of people who are critics of public reason, including those people, I think one can kind of articulate a kind of representative alternative position, which includes this idea of kind of iterative dialogue, plural justifications, but converging on shared principles of justice. And so the critics come back and say, well, if we have this alternative conception of legitimacy, then what's the point? So it does seem to me that it would be helpful to reframe the discussion and to ask the question, what difference might a practice of public reason make in a democracy in facilitating justice? Or does it make any difference? So that's what I've been thinking about. I guess I might just say a word about the Rawlsian point of view, since that's sort of in the background here and it's a diverse and open group. So, so the Rawlsian viewpoint, I think all Rawls does in some of his work, John Rawls, most famous, most important political philosopher since John Stuart Mill, and so on. He says, he emphasizes this problem of political legitimacy, that in a democracy we want laws, especially those that touch on basic rights, very important moral issues, to be justifiable from everyone's point of view. We'd like the Constitution to be something that everyone could buy into. But we have this problem of diversity, religious diversity, philosophical diversity, and so on. So how can we have a common justification if we have this problem of religious and philosophical diversity? So he I think systematized in effect ideas that have circulated in liberal democracies for a long time: social contract tradition, constitutional traditions, and so on. Political liberalism, and the two ideas are we accept the fact of reasonable pluralism. This diversity of views about philosophical and religious truth are permanent, number one. Number two, we emphasize that political power in a democratic community belongs to everybody, so we do want a justification for everybody. And number three, the solution is this idea of political liberalism, which includes two sorts of ideas. Let's look for those morally powerful notions that have wide circulation in the political community, that have developed over the course of time: citizens as free and equal, society as a fair system of cooperation, and other ideas that have wide currency. And also an idea of public reasoning that we all ought to share for these sorts of questions, these sorts of political questions, a common account of how we go about arguing about them. We ought to cite reasons and evidence, as I was indicating before, that we could all share, and sources of evidence, again, that can be shared with everybody, proofs, evidence drawn from various ways that we could all share. So anyway, he develops all of that and says that support for these shared forms of reasoning is a duty of citizenship. And that ideally, the sort of gold standard for him would be if we converge on well-justified principles of justice and a common case for these principles of justice, a shared account of citizens as free and equal, society as a fair system of cooperation, citizens with two moral powers. There's a sort of apparatus to it, not really all that complicated, but it kind of fits together in a package, and it would be great if we all could converge on such an account, that account or some other. So as I said, the critics have responded to the legitimacy point, and the critics have responded to the legitimacy point and have their own alternative views. Lost my notes. Do this without it, I suppose. There it is. Wrong pen. Sorry. That didn't look right. Okay, so I want to argue for the practical importance of political, and based on a reframing. And the reframing is going to emphasize two things. One is the importance. A big part of this debate has tended to emphasize the coercive powers of the state. We have this legitimacy problem because the state has coercive power. And I think this theme has circulated in part because of debates about international justice. What distinguishes international justice from domestic is domestically there's coercive power in the state, internationally it's more kind of voluntary that states participate in international institutions. But that's potentially misleading. Insofar as a democratic community actually achieves justice, it's going to be because there's buy-in from citizens. So I think it's important to emphasize, I think this is just perfectly realistic, and all sides of this debate should accept this. We will have justice in our community insofar as the public mind is won over for justice. The battle for civil rights was actually ultimately a battle for the public mind, to try to convince people, of the principles. African Americans were going to be insecure, and were insecure. It wasn't enough for the Supreme Court to decide things, for amendments to get passed and so on, for things to come down on high, or even for northern armies to occupy the South for a while. The public mind in the South had to be won over, and African Americans were going to be insecure until they were won over. Gays and lesbians are going to be insecure on the streets unless they can count on their fellow citizens to support their rights and so on. Women will be not have equal opportunity in the workplace unless they can sort of count on a general ethos of non-discrimination, non-harassment, even not telling off-color jokes and so on. So it seems to me that one of the things we want to accept, and I think there's ample empirical evidence to accept this as well, that well-functioning democratic regimes are places where the basic laws of the community have the support of social norms. And indeed, lots of studies of effective criminal law show that criminal law, maybe we went to the wrong place or something. They call it that together. I don't think I'm going to start over, since I'm supposed to be ending. Anyway, it's about public reason. So the reframing is decentralized, democratic. These people all here.
Is everyone here for ethical theory and practice?
We were in the wrong class.
We're in access. Okay. Welcome anyway. I'll talk at the end a little bit about the class. So.
Okay. So anyway, I'm talking about it. Sorry. Lots of things. First up,
where are all the students? There are 30 people signed up here.
Let's see. All right. So anyway, it's a bit of why public reasons matter. Why might it be important in democracy for people to offer shared reasons? And there's been a big debate about this because it seems to suggest that offering religious reasons for very important laws is not altogether sufficient. So I was suggesting that an important reframing is to, first of all, notice that justice won't really be, people won't be secure in their rights. They really won't enjoy the benefits of equal opportunity and so on unless there's general buy-in from the rest of the political community. And on the basis of that sort of reframing and the problem that gives rise to, I want to argue that a practice of public reasoning, a democratic practice of public reasoning, can fulfill 6 important functions. There's really sort of 3 with 2 parts. One is to solve a problem of mutual assurance, based on common knowledge. Another is to provide resources for interpreting, extending, applying, and revising the law. Third is providing resources for the induction of new groups and the education of rising generations. It seems to me practices of public reasoning are quite important for that. Fifthly, facilitating the public agenda. And 6th, special concern for the least well-off. I'm going to go through these very briefly. I'm really going to emphasize the first 2. So given this issue about decentralized enforcement, I mean, if I'm right about that, and again, I think I am, there's ample, what I was saying when people started walking in, was that there's ample stuff in criminal law that says that the criminal law departs too far from social norms about desert. It's not going to be effective. And there's lots of stuff about, basically with taxes and the draft and other sorts of things, you count on a fair amount of voluntary compliance. There's an enforcement mechanism in the background. Don't want to deny that that's important. But we basically count on most citizens to pay their taxes, to go along with things, and indeed to complain if they see other people not going along with things. So it does seem to me that an effective system of law depends upon a lot of community buy-in. Now, that gives rise to a problem, which is that if I'm disposed to act in support of some norm of justice, to comply with it or to complain if I see someone else violating it, there are costs attached to that. That could be costly behavior for me. I'm sort of putting together here a kind of rational choice model and a political theory model. I've been collaborating with economists and stuff like that. So the cost is you may be uncertain as to how your fellow citizens are going to behave. Successful action of that sort depends upon my complaint about the way I see someone treating someone else. Other people basically going along. I don't want to go out on a limb, if it turns out, I'm just wrong about what other people around me think. So, and this is a special problem in a diverse political community, where people have lots of different religious views, lots of different philosophical views, as I said before, different ethnicities and so on, come from lots of different places. So in a diverse political community in particular, we may be very uncertain about the disposition of our fellows when it comes to some of these basic issues. An additional thing is that, of course, once we've passed a law, as I indicated, well, so what? Laws are often, quite short, but not always. I'm not true about the healthcare law, but that's kind of law for administrators. But lots of issues about rights and so on are quite short. And the question is, what do they mean? What does the Bill of Rights mean? What does the Equal Protection Clause mean? And so on. It has to be interpreted and applied in different circumstances, and we need some help doing that as well. And indeed, we need some confidence, perhaps, that we're all on board for a certain kind of interpretation of those things over the course of time. So it seems to me that we have this problem of mutual assurance. It's partly interpretation of rules, and partly, as I said, some rational choice. Excuse me. And a practice of public reason can help solve this problem of mutual assurance and solve it the way we need to solve it as a matter of common knowledge. So the idea is, if there's a practice of public reasoning in which we, as citizens, consciously sort of articulate the case and participate in articulating the case for shared principles of justice, that will help to reassure one another that we're all on board for this project. And we need that because in order for it to be rational, to act in support of shared principles of justice, we need two things. We actually need two of the things that Rawls emphasizes: an overlapping consensus. How many people have read Rawls? Some people have read Rawls. Okay, everyone should have read Rawls. Don't let these people leave without reading Rawls. You need overlapping consensus, which is to say people converge on shared principles of justice from their different religious and philosophical standpoints. The critics of public reason go along with that. But we also need to practice public reasoning so that we're articulately reassuring one another that we agree, in effect, to a sort of common logic of justice that we're all prepared to go along with. And that's the point of Rawls is constantly talking about in his work, that what we count on is reciprocity. I'm going to support fair principles of cooperation, given that we're all going to support fair principles of cooperation. The motive for justice, Rawls says, is not just altruism or being saintly and so on. It is being willing to participate in your society fairly, which is to say on terms that other people could accept. And there's a kind of reciprocal commitment to that sort of fair action is an important part of what justice is about. So we need two things to solve this problem of mutual assurance as a matter of common knowledge. We need the overlapping consensus plus a practice of public reason through which we articulately reassure one another that there's a kind of common logic of justice which we share in our society, apart from all the particular logics that we also have, in effect, religious, philosophical, and otherwise. So an articulate, formative practice of public reason, I think, can be extremely helpful that way. And as I say, it helps to address this problem of mutual assurance. It also is extremely important with respect to this general problem of interpreting and applying law. Again, as I said, we have these rather general laws, these rather general commitments to religious freedom or to equal protection or whatever. But what does that amount to? What does that require in particular circumstances? What does that require when new circumstances arise? Because really what we want is the assurance that we live, we're part of a community that's committed to a certain conception over the course of time. These guidelines of public reasoning, the commitment to debate things and so on in terms that we can share, in terms of evidence that we can share, is also hugely reassuring to people, including when we disagree. So what the guidelines of public inquiry say and so on is that, well, we may disagree about whether affirmative action is constitutional or just, or what the limits of religious liberty are. But it'll mean a lot if we're committed to debating those sorts of issues on the basis of shared reasoning, shared forms of inquiry, and so on. So that also, I think, is hugely important. Then I'll just mention very briefly the other, I have a little more time because you start at 7 after. The other positive reasons, I think, here. First of all, new groups forming in society. The critics of this idea of public reason want to say, look, all we want is for people to converge on principles of justice. It doesn't make any difference whether we have shared forms of reasoning. And indeed, they also tend to say that religious reason should provide people with, I'm not going to try to present, but defeater reasons. You don't need to enter into a shared point of view, and your religious perspectives give you kind of automatic defeater reasons for vetoing public laws. Sort of complicated there, but part of what we want to think about is so what do we owe to new groups that enter society, or to new groups that form within society? What do we expect of them? And again, I think this practice of public reasoning is an important part of the fair induction of new groups into our society, and also the education of rising generations. So I think one of the things that we properly expect of new groups is that they should learn about the traditions of our society, the traditions of the interpretation of these fundamental norms, and the sort of guidelines that allow us to debate these things as a democratic community together. Now, that's what I think they owe to become part of the political community, part of a shared, liberal democratic constitution. On the other hand, what we owe them, and I think this is a very important part of this ideal that critics have focused on, and I think the formulation of this needs to take this into account, we owe them a fair hearing. If on account of the peculiarities of their religious views, or their ethical views, the general law imposes some sort of special burden on them. We do owe people a fair hearing, and it has to be part of the sort of inherent bargain, and I think you can actually build it into the rationality story, that this convergence on shared principles, this consensus on shared principles, will be on the basis of free assent and on the basis of an open invitation to contest and given ample opportunities to listen and to hear complaints. This is part of liberal democratic constitutionalism. It's one of the reasons why we have a politically independent court to hear complaints from religious groups and so on. But it's very important because any of us might become a dissenter on some particular issue in law. Any of us will want the assurance going forward that should we convert to a minority religion or develop philosophical views that create some tension with some aspects of law, we'll get a fair hearing, for our particular non-public philosophical views. So I think we can build into this that sort of flexibility. We ought to, we have to, because this is meant to be a liberal democratic view. The idea is that we converge freely on a shared principles of justice, which also stands up to scrutiny from all points of view. So I think with respect to new groups and rising generations, the two things are that on the one hand we should expect learning about the shared tradition, on the other hand we should regard the shared tradition as open to criticism, contestation, and revision and complaint, and there have to be procedural mechanisms to deal with that. That's, of course, very familiar to liberal democratic constitutionalism. It just becomes a question of how we should formulate that. So what did I say? The other two things were just the other two practical purposes. We're facilitating the public agenda. Again, it seems to me that there's a certain kind of impracticality in the model that's provided by these convergence types. I mean, it just seems to me that having a kind of shared body of reasoning is of huge value, and likewise shared forms of reasoning. And then finally, it does seem to me that it was worth thinking about who most depends in our society on the kind of mutual intelligibility that comes with having shared principles that we all understand, shared principles that we're all committed to, and that we're all prepared to affirm in public, in a sense. Well, it's going to be those who most depend upon principles of justice and rights, namely, the relatively vulnerable and minorities. So I do think that a lot of this is most important from the standpoint of those groups whose rights are most likely to be fragile if there isn't kind of general community support for principles of justice on terms that are mutually intelligible. So I would say this is all from the standpoint of the least well off in particular. Let's see. So that's the basic argument I wanted to make. There are also, given the way I've reframed this as a kind of public reasoning, as a kind of duty among citizens, as a practice among citizens that we have a kind of responsibility to engage in, there are going to be worries about police, speech police, and whether this leads to kind of mutual checking of sorts that are sort of creepy or political correctness and so on. I think those are the sorts of things that have to be taken into account. I mean, I think those are worries, but I think there are worries that, again, quite common. There are lots of things we would regard as quite offensive. People say there are lots of jokes that are just off the table, and so on. So I think that's where we are, and I think it's a perfectly reasonable place to be. I think I'll just end there and open it up.